matter of Granville Technology Group Ltd, into brackets, in liquidation and others, and Chunghwa Picture Tubes Ltd and others.
Yes.
Thank you. My lords and my lady, I appear on behalf of the appellants. My learned friend, Mr. Pitchin in King's Counsel, appears with Miss O'Keefe for the defendant respondents. One housekeeping matter. I understand that the court has kindly approved transcribers who are dealing this remotely. I'm not aware whether they're going to request a break, and I wonder if they do, whether the court will be minded to allow them a break.
Oh yes, if
I will try and...
they or anyone within reason requests a break, that'll be fine.
Thank you, my lord. Well, I will be tugged if a break is requested, and I'll pass it on. Thank you. May it please the court, the central question before the court today is as to the meaning and width of Lord Brandon's obiter dictum in President of India, La Pintada Compagnia, that one of the circumstances in which the Chancery Courts have awarded compound interest is where money is obtained and retained by fraud. The basis and circumstances in which interest may be awarded, particularly compound interest, has divided judges at the highest levels. Lord Gough, in his dissenting speech in Westdeutsche in Islington London Borough Council, observed that our law of interest has developed in a fragmentary and unsatisfactory manner, and in consequence insufficient attention has been given to the jurisdiction to award compound interest. In my submission, that comment is particularly apposite for the issue before the court today. Despite the industry of both sides, no authority has been identified in which the court has explored precisely what Lord Brandon intended to encompass within his dictum, and it's an area which in my submission remains unexplored by the courts. And in fact, my lords and my lady, no doubt reflecting that it was an obiter dictum, Lord Brandon did not identify the authorities that he had in mind when he expressed that dictum, and I'll show you later that in the Westdeutsche case, Lord Wolfe sought to identify where perhaps it could be traced from, and that leads us into something of a black hole as well. So, in consequence, it's my submission that the court is navigating territory without a detailed map, and added to this are the well-recognised difficulties historically in defining fraud, and in particular the complexity arising out of what equity has historically characterised as being fraud. My learned friend's respondent's notice, or his client's respondent's notice, raises a further question which wasn't explored at the first instance, which is as to the import and meaning of the expression obtained and retained by fraud. And my learned friend's submission is that this requires the receipt of money belonging to the claimant. Suffice to say, these are deep waters which we say remain unexplored. And in my submission, it's not usually or ever appropriate to strike out a claim or a part of a claim unless the court can be certain that it is right to do so, and it is not, in my submission, appropriate to do so in an area where the jurisdiction is evolving or undeveloped.
They may be deep legal waters, but it is a point of law, isn't it? As distinct from something which is going to be affected by facts which may come out of the trial. Is that right?
It may be affected by the facts that come out at trial, particularly where one is asking or looking at the question of obtained and retained. The decision of the Commission has already, which I'll show you a few passages from momentarily, has already established what you might say is the breach and liability. What is an issue at the trial in next term in October is effectively questions of causation and quantum. But in that trial, in exploring causation, in my submission, there will be an exploration of whether or not prices were pushed up and whether there was overcharging by reason of the price-fixing cartel. So the court will be exploring the facts surrounding what actually happened in the cartel. So there may be relevant findings there about the nature of what we say is the wrongdoing on the part of the defendants.
But aren't the other side entitled to say, if taking your factual case at its highest, there can be no claim for compound interest, then now is the time to say so.
Yes, that is right, and that goes to the other point, my lord, which is about the need to have clarity on what the legal position is. So the question was, is it purely a question of law? It isn't, in my submission, purely a question of law. There is a question to be determined in my submission properly at trial, in light of the court's factual findings, as to what the extent of the jurisdiction in equity is, and whether it's engaged on the facts of this case. And in my submission, the extent of the jurisdiction requires a great deal of argument and will ultimately require a great deal of archaeological work in order to identify it, which hasn't yet been done, in the sense that what is effectively being said is when Lord Brandon said fraud, that must mean dishonesty. I think that's what the position is of my learned friend. And we say, well, that's not, we say correct. And we say that even if it is dishonesty, we say that there's a very real question that we've met that test. If one takes the standard understanding of dishonesty from Barlow Close.
Well, we have cases in the bundle going back, I think, to 1750, which quite a lot of cases cited, which suggests to me that the archaeological work has been done, and that between you are in a position to put before us such case law as there is as to what the courts of chancery used to do.
Yes, I'm going to seek to do that. What I say, though, is that the question of what equity regarded as fraud is one that isn't hard-edged, as the judge accepted. And it is a question which, therefore, isn't so easy to answer. And therefore, simply saying this isn't a claim in deceit doesn't get my learned friend home. Simply saying this is not a claim where it's been done before doesn't get my learned friend home. It may be useful if I map out the argument very briefly before I launch in. Thank you. The judge held that Lord Brandon's dictum requires that fraud is the cause of action or an element of it. And our ground one proceeds on the basis that that was correct, and we submit that the appellant's claim is one that nonetheless falls within the ambit of the word fraud. We recognise that that's a new argument that we didn't advance it on those terms at first instance. We say in the alternative that the judge was incorrect in his conclusion that fraud must be the or an element of the cause of action, and that's ground two. Just to briefly illustrate that, perhaps. The formulation used by Lord Brandon was obtained or retained by fraud. So I'll seek to show that appears to have derived from Crown and Johnson, where the expression used was obtained by fraud and retained by fraud. And there's also a decision of the Court of Appeal where Lord Justice Norse used the expression obtained or retained by fraud. And to give an example, if a party obtains someone else's money by reason of a non-fraudulent transaction, let us say a payment is made on account for work to be done by the defendant for the claimant. The defendant does less work than was anticipated, but when the customer makes inquiries about the work that's been done, the defendant lies and misleads him as to how much work is done. And on that basis, the claimant doesn't pursue the monies that the claimant is entitled to. The claimant discovers later that actually he'd been lied to, and the claimant brings a claim to recover the monies. Now, in those circumstances, my submission, the claim might well be a non-fraudulent claim to recover the monies is not based upon a fraud, it's based upon the terms of the original contract, not a fraudulent claim. But the defendant has been able to retain money by reason of its fraud for longer than it would otherwise have been done. And the question that would arise in those circumstances is whether or not it would be appropriate for compound interest to be paid by the defendant in respect of the monies that it held on to by reason of its fraud. And if that were sufficient to engage the court's jurisdiction, because it's been retained by fraud, it would follow, therefore, that fraud doesn't need to be part of the cause of action itself. And that would be why we would say that ground 2 would be right. And in this case, the defendants are, we say, liable for their involvement in a price-fixing cartel, that they deliberately concealed the existence of the cartel, as the Commission has held. And for the purposes of the application, it was accepted by the judge, and certainly we say is right, that deliberate concealment of a wrong may, in appropriate circumstances, be capable of being characterised as an equitable fraud. We say it's therefore the case, and certainly arguably the case, that a defendant that conceals its involvement, and indeed the existence of a cartel, thereby acts so as to avoid meeting its liability, and it's thereby retaining money by reason of that concealment. And we say that that can, not at least arguably should, engage equities jurisdiction. So ground 1, so we say the claim is one that equity would characterise as fraud. Ground 2, the judge was wrong in concluding that fraud needed to be part of the cause of action. I'm paraphrasing the grounds at the moment, I should say. And we say that whether those propositions are in fact correct ultimately, we say they are correct, but it may require further exploration in light of the factual findings, and it's an area of developing jurisdiction, or certainly undeveloped jurisdiction. We then have the respondent's notice point, where the defendants now say that the equitable jurisdiction requires that the money received by the defendant belonged to the claimant. This point wasn't advanced below. It involves a gloss on the words used by Lord Brandon and in Crown and Johnson by Lord Norton. And we say it's wrong. And then ground 3 relates to the judge's refusal to allow amendments that were proposed to address his anterior conclusion that there was no sufficient pleading that the defendants obtained and retained the fund. And our broad submission on that is that the judge's view of ground 3 very much was based upon his analysis and findings in respect of the nature and scope of equities jurisdiction. Before I turn to ground 1, I wish to address a couple of points made by my learned friend in his skeleton argument, with of course, indulgence. It's said by my learned friend at paragraph 39 of his skeleton, which is in the core bundle at tab 6, page 82. It's the first full sentence in this paragraph 39. It said, multiple compositions of the House of Lords and the Court of Appeal have concluded that compound interest cannot be awarded in situations where it had not been previously applied. There needs to be some care in...
Sorry, where were you reading?
Paragraph 39, page 82, midway down through paragraph 39.
Oh yes, sorry, found it now. Thank you.
We say there needs to be some care on this point because we're not submitting that there is a new category that should be created. So our argument that the claim comes within one of the existing categories, fraudulent. And it is right that we haven't identified a case in which compound interest has been awarded under the equitable jurisdiction in respect of damages for this type of claim. But we say that's not conclusive. And
well, Sempra says the opposite of what the respondents say here. Because Sempra says, never mind all the previous multiple decisions, bad pennies keep turning up and it's time to change things.
Indeed, indeed. And we may look at it, but there is also similarly discussion in the minority judgments in Westwich about the fact, the flexibility of equity. But the point I want to make here is, if it fits within the principles, it fits within the principles. If it hasn't been applied before, it doesn't mean it's not outside the principles. And that point was in fact made by Lord Brandon in La Pintada, which is in the authorities bundle at 1. Sorry, I ought to have asked. My lords, my lady, are you working electronically? I think you...
I'm doing authorities electronically, so could I have the electric page,
Yes.
please?
And I'm, to be difficult, working from authorities, but not necessarily the same bundles, so it'd be very helpful to me if you could give the tab number.
My lord.
Hard copy. You can't go wrong if you cover both pages.
Yes, I'm fairly confident that the pagination in the bundle matches the PDF pagination. Please do say if not, and I will do some arithmetic in my head once I know how far out we are. So it's tab 1, sorry, bundle 1, tab 9.
It looks like they're the same.
Thank you. It may be worth just noting very briefly what the facts were in this case, but very, very briefly. I'm sure you're to a certain extent familiar with it. This was a claim, there was a claim brought by way of arbitration for unpaid freight and demurrage due under a voyage charter. The sums demanded were paid after the arbitration started, but before it concluded. And the arbitrator held that the monies should have been paid sooner and awarded compound interest. The House of Lords in this case held that the arbitrator had no power to award such interest. And they did that in large part because the House felt it was bound by and was not appropriate apart from the rules set down in London, Chatham and Dover, which has since, of course, been overturned in Semprametals, the part of Semprametals which wasn't itself overturned by Prudential. So this wasn't a fraud case at all. And Lord Brandon at page 215, and in the report I think that should be page 120, discusses the historical basis upon which compound interest has been awarded. For present purposes, I just asked you to look at B, 120B or 215B. He referred to the Aldora, and he noted that he decided, sitting as a judge of the Admiralty Court, that the practice of awarding interest in damage actions could and should be extended to salvage actions by the award of interest on sums for which judgment was given in such actions. And the principal argument addressed to me against such extension was that neither the Admiralty Court nor its predecessors had ever awarded interest on sums for which judgment was given in salvage actions before. And he answered that, you can see in the indented paragraph, and that is the last two sentences after D. The main argument against applying the principle to salvage actions is that it does not appear to have been done before, when what is involved is no more than implying an equitable principle long established in one class of case to another class of case, in which is equally or even more appropriate. I do not think that this argument should prevail. And we say that's analogous to our point. If we're within the principles, we're within the principles. It also meets a submission by my learned friend at paragraph 22 of his skeleton argument. For bundle 6. Page 74. Paragraph 22, it's submitted that the question becomes whether secret cartel damages claims can be shoehorned into the fraud limb. If this court held that the answer was even arguably yes, that would radically alter the basis on which cartel damages litigation in this jurisdiction is conducted. And then he refers to case, the first instance decision of Mr. Justice Marcus Smith in Britned and ABB. 4 points on this. Firstly, the fact that the argument might have ramifications is not, in my submission, a coherent or principled reason for concluding that the claim doesn't come within the court's equitable jurisdiction. Either it is or it isn't. And one doesn't reason, or one ought not to reason backwards. Second, what my learned friend submission emphasises is that this is a point of importance. Third, in the Britned case itself, it was not argued that compound interest was available in equity. The claim for compound interest was put on a Semprametals basis, so the claimant sought to plead and prove that it could claim interest as damages the claimant failed because what the claimant sought to do was not claim its own loss, but effectively the losses of its shareholder. So it just failed on ordinary principles that it hadn't established that it had suffered a loss itself. The question of equity's jurisdiction wasn't argued or raised. It was also noted in BritMed, I don't think we need to turn to it, but at paragraph 423, for the court's note at tab 23 of Authorities Bundle 3, page 1090.
It's slightly, makes it slightly difficult, I speak for myself anyway, if you're alluding to cases on the assumption that we must know them. I mean, my Lord Justice Nails may know that case by heart, but I don't.
No, I'm afraid I don't think I've ever opened that case. So
I will.
If you need something, then you'll have to show us.
Point taken. I will show you it. It's Authorities Bundle 3, tab 23, page 1090. This was a follow-on damages claim. And sorry, it's not 1,000. I think I said 1,190. Yes.
1,090 or
1,090. Yes, it's
1090.
Yes. Paragraph 423, where the judge said, "This is, I understand, the first claim for damages arising out of a restriction of competition contrary to Article 101 FEU /Article 53. The question is therefore to an extent an open one." This is a question, a slightly different point that he was addressing. So this is also, we're also dealing with the claim for compound interest in relation to a type of claim which is itself relatively new. This decision was handed down in, I think, October 2018 and reported in 2019. So it isn't a case where we have generations of claims where these arguments have been flushed out and they've been refused. So having made those preliminary points...
So claim being, the point you're making is that it's a claim in a competition context. Is that the point?
Yes, yes, a follow-on damages
Follow-on
claim.
damages in a
My
competition.
learned friend's submission being that you can't possibly, what we say can't possibly be right, because it would radically alter the basis upon which these claims are being litigated. My principal point you have is...
So what?
So what? And that was somewhat a subsidiary point, which is, well, it's an area that's evolving itself. Ground one, then. Ground one is that the learned judge erred in law in holding that the appellant's claim is not, or not arguably, based upon a cause of action which equity would regard as fraud or as having fraud as an ingredient.
I mean, if Mr. Justice Marcus Smith said so, I'm sure it's right, but it seems a bit surprising that only in 2019 was the first judgment on a claim for damages under Article 101 or its predecessors. Competition lawyers have been in business for decades, I thought.
It may be that it's the particular type of follow-on damages claim or not. It's perhaps not so much my wheelhouse at that point. I took it from that judgment. If the judge was wrong, then the judge was wrong, but I took it from that judgment. Now, ground one. The way it was argued before the judge below was not that it wasn't argued that involvement in a price-fixing cartel is sufficient in itself to come within Lord Brandon's meaning fraud. It was argued that it was the concealment of the cartel amounting to serious and intentional wrongdoing, which was behaviour which engaged the jurisdiction. And I wish to show the court how far the judge went with us on that argument. The judgment is in Core Bundle, tab 10A, page 105. And I'd like to start at paragraph 32, page 130. court has read the judgment, of course, so you'll see that the judge quoted from a discussion in Grant and Mumford on civil fraud as to the meaning of fraud. I don't propose to read it out, but the point that comes out of that is perhaps best seen on the just over the page. It's the second paragraph, the first full paragraph there, which discusses the long and complex history of fraud in the court's equitable jurisdiction, and how equity developed the twin notions of constructive or equitable fraud and actual fraud, and the former extended to conduct which involved no form of dishonesty. And there's a reference to Nocturne Ashburton, which I may take you to in a moment. Now, you'll see that if we then go to paragraph 33, the judge begins, fourth sentence, in the event the oral argument was put on a rather broader basis, so as to include what is often referred to as equitable fraud, which does not or need not have a dishonest component. Such are the concepts described in Grant and Mumford, and I certainly accept, at least for the purpose of the present application, the conduct fitting that description may in principle fall within Lord Brandon's use of the word fraud. For example, I would expect an allegation of undue influence could well do so. It might not in such circumstances be necessary to plead in terms the confirmatory statement that undue influence is a species of equitable fraud. Well, that last point is because a pleading issue was said. It was said, well, if you're going to say it's fraud, you need to use the word fraud in your pleading. But the judge was here accepting, well, if it's equitable fraud, which is distinct, then one that wouldn't necessarily have that requirement. He didn't decide it on such a pleading point. Now, in paragraph 34, he refers to my submission, which he also accepted, that the boundaries of equitable fraud are not hard-edged. Now, the discussion, the judge begins at over the page, and it's paragraph 37 onwards. Just want to look at these purposes at paragraph 38. I would assume without deciding that in theory at least, conduct which involves the deliberate concealment of a wrong may in appropriate circumstances be capable of being characterised as an equitable fraud, given the very broad scope of the concept described in Grant and Mumford. Now, the judge was prepared in my submission rightly to accept that it's certainly possible that the concept of fraud in equity, which isn't hard-edged and didn't necessarily require a dishonest component, might apply to Lord Brandon's description of the equitable jurisdiction. Now, it's convenient, having seen what the judge said, to note what my learned friend says. My learned friend says in paragraph 37 of his skeleton argument, same bundles, which is core bundle tab 6. He says that our ground one is a hopeless contention. As explained above, the House of Lords concluded in Re Norris and Crown and Goldshield Group that secret cartels are not without more dishonest. I'll come to those authorities. But the immediate point to note is that built into that submission is a premise, and the premise is that fraud for the purposes of Lord Brandon's dictum requires dishonesty, which my submission rubs up against the way the judge was prepared to look at it, and my submission rightly, which is that fraud in this context doesn't necessarily require dishonesty. And no authority cited by my learned friend to support that particular narrow formulation of the word fraud. Indeed, in my submission, none of the cases do identify or support such a contention. And as I said, this implicit premise is not easy to reconcile with the judge's approach. And so consequently, at this stage, we already have a significant dispute as to what actually is the nature of the jurisdiction. Even if it is dishonesty, which my learned friend suggests, then the question arises still whether or not participation an unlawful price fixing cartel is dishonest. It involves concerted practice with the object or effect of distorting competition. Now, the court will be aware, and I'll show you the relevant passage in a moment, that is made clear by the Privy Council in Barlow Close International and Eurotrust International Limited, and the criminal law has been brought into line with this since I've been genting, that dishonesty can effectively involve participation in something which transgresses ordinary standards of honest behaviour. And one might ask rhetorically how it can be said that engaging in a price-fixing cartel which is unlawful doesn't transgress ordinary standards of honest behaviour.
But if that were enough, the case law would be a great deal more simple. If Lord Brandon had said if defendants behave in an unconscionable or dishonest way, they can be liable for compound interest, one could get rid of most of the 33 authorities in the bundle.
Lord Brandon didn't express himself in that way because it was in a passing obiter dictum in which he was not actually focusing upon equity's jurisdiction. I will take you to where it seems that he may have derived that expression from. But in my submission, as I will seek to show you in a moment, equity has long had a wider meaning of fraud, as the grant and monthly extract suggests. And the fact that Lord Brandon didn't, in a case where it was unnecessary to do so, seek to expand and develop precisely what it was, my submission doesn't answer the point.
Well, he may be right or wrong in what he said, but my recollection is that Lord Brandon was a pretty precise judge in the way that he formulated propositions.
Yes.
And said and meant to say exactly what he meant.
Yes, and he said fraud, but he didn't explain what he meant by fraud, and that's the issue here. He didn't say fraud as in the tort of deceit. He didn't say anything beyond the word fraud.
Well, it may be more that he said obtained and retained.
Yes, which very much comes into the respondent's notice point and possibly ground 2 as well. Now, it is then at this stage perhaps helpful to look briefly at 2 examples of how equity has historically looked at fraud, or what has been characterised as fraud.
Yeah.
In Authorities Bundle 1, we have Earl of Chesterfield and Janssen from 1750. But it's at tab 1 of Bundle 1. It's a long report. It's unnecessary to get into the facts in any detail. We can see the point from, or the issue from page 5 at the top. A bill was brought to be relieved against the defendant's demand as an unconscionable bargain and usurious contract. Suffice to know that what had happened here is that there had been a contract under which monies had been loaned, and there was an agreement to repay it with a very large, what you might say these days was a penalty, which was contingent upon the death of the father, I think, of the borrower. And the question was whether or not this, when then there was a demand made upon that bond, whether or not it should be set aside effectively. And Lord Hardwicke's judgment, page 36 of the bundle, fourth paragraph down, you can see the words in italics, Lord Chancellor. And if we go to the end of that paragraph, he he identifies the first point is whether the first bond is void in law by virtue of the statutes of usury. We don't need to worry about that. Then he said the second point, if it is valid in law, whether it is contrary to conscience and relievable upon any head or principle of equity. And at page 37, so over the page, I dealt with that. It's just about halfway down. You'll see the words on the second head. And it's the next paragraph. He says, no wise and good man will assert such bargains deserve encouragement, for as they are productive of prodigality on the one hand, so do they beget extortion on the other. Want and avarice always generating one another. These contracts may be truly said to be vitia temporis. This court can certainly relieve against all kinds and species of fraud. Fraud may either be dolus malus, a clear and express fraud, or fraud may arise from circumstances and the necessity of the person at the time. There are also hard, unconscionable bargains which have been construed fraudulent, and there are instances even where even the common law hath believed for this reason. Now, the point there is that you can see immediately that the word fraud, or that even hard, unconscionable bargains have been construed fraudulent in the terminology used by the Chancery Court. Now, this point is then further developed in the case of Nocton and Lord Ashburton at tab 7, this authorities bundle. Begins at page 115. This is a decision from 1914. So it's decided after Derry and Peake had brought some clarity into what was required for claims in deceit. Although this case resolved some residual uncertainty, the essential facts which are set out in the head note is that a client sued his solicitor. The client had loaned money to a third party on the security of a mortgage. The solicitor gave the client advice, following which the client released part of the security. It meant that the client was undersecured for the loan. The solicitor was then himself able to take security over the asset for a loan of his own. And you'll see where it says held in the head note that in the circumstances, it says Neville J. Neville J. found that the charge of fraud was not proved and dismissed the action. The Court of Appeal reversed this finding and granted relief on the footing of fraud. Held that in the circumstances the Court of Appeal was not justified in reversing the finding of fact, but the plaintiff was not precluded by the form of his pleadings from claiming relief on the footing of breach of duty arising from fiduciary relationship, and that he was entitled to relief on that footing. And Lord Haldane gave the principal judgment, which we can pick up at page 128. Final paragraph. Viscount Haldane said, I cannot treat the case so far as based on intention to deceive is made out. So this is where he was saying that the trial judge shouldn't have had his finding of fact disturbed. But where he differed is from the learned judges in the courts below is their view that if they did not regard deceit as proof, the only alternative was to treat the action as one of mere negligence at law, unconnected with misconduct. And over the page, about 5 lines down, you notice there's a third form of procedure to which the statement of claim approximated very closely, and that is the old bill in Chancery to enforce compensation for breach of fiduciary obligation. There appears to have been an impression that the necessity which recent authorities have established of proving moral fraud in order to succeed in action of deceit has narrowed scope of this remedy. For the reasons which I'm about to offer the Lordships, I do not think this is so. And if we go to the next page, at the bottom, there's a paragraph where his Lordship said, even the action on the case of deceit was itself revolved by the judges, sustained by the dissenting judgment of Gross J, Pasley and Freeman, so comparatively recently as 1789. up to that date, it was at least doubtful whether the action lay in the absence of a special duty. And it's over the page. Well, he makes that same point, actually, that we looked at before, where he refers to, he says, these doctrines and the like illustrate the freedom which has been exercised by the judges making new applications of recognised principles. But the critical point I wish to show is...
Do you want to tell, where is that?
Oh, sorry, I do apologise. It's about 10 lines down, just after the number 2.
Yep.
And it's page 134 at the bottom. My lords, it is known that in cases of actual fraud, the courts of chancery in common law exercise a concurrent jurisdiction from the earliest times. And over the page, second paragraph, but in addition to this concurrent jurisdiction, the Court of Chancery exercise an exclusive jurisdiction in cases which, although classified in the court as cases of fraud, yet did not necessarily import the element of dolus malus. The court took upon itself to prevent a man from acting against the dictates of conscience as defined by the court. Now, and actually that's reinforced over the page, 136, in the penultimate paragraph, about 5 lines up. He said, in Chancery, the term fraud thus came to be used to describe what fell short of deceit but imported breach of a duty to which equity had attached its sanction.
Studied this case many years ago, but doesn't it turn on the special duty owed by solicitor to client? So even if solicitor isn't a fraudster, the duty goes beyond just being careful.
It does. The point I wish to take from this case is that in addressing why the courts were wrong below, Lord Haldane discusses the fact that equity has used the expression fraud and fraudulent in a wider and different way to others. And in fact, if we go to the next page, actually there might be... Yes, we can go straight to page 140. My lord, this will hopefully shorten it. And the first full paragraph on that page, my lord, since the Judicature Act, any branch of the court may give both kinds of relief and treat what is alleged either as a case of negligence at common law or as one of breach of fiduciary duty. And there's an illustration referred to. It says, then it said, importantly, in the case with which we are dealing, the statement of claim was framed mainly on the lines of breach of fiduciary duty. That was probably deliberately done in order to endeavour to get over the difficulty occasioned by the statute of limitations. And then, next sentence, as a consequence, fraud has been charged in the peculiar sense in which it was practiced to charge it in chancery procedure in cases of this kind. But the facts alleged were nonetheless, if proved, afforded a ground for an action in mere negligence. So the point there is that even a claim for breach of fiduciary duty akin to negligence would actually be treated as possibly being a fraud claim in chancery, which is why we have this issue as to what is the scope of fraud in Lord Brandon's dictum.
This case, seems to be all about somebody who is in a fiduciary relationship.
Yes.
Is there a case which equity has regarded conduct as falling within its concept of fraud, which does not involve a fiduciary relationship or something akin to it?
We have the case of Mann, decision of Lord Justice Moore-Bick, which was a claim in deceit, where he ordered compound interest, which I'll show you. And Black and Davies, in the Court of Appeal, it was also a deceit claim, my submission, the reasoning of the Court of Appeal, which was overturned, but the reasoning why compound interest wasn't available there was not because there was no fraud, but because didn't meet the obtained and retained requirement, because the fraudster in that case didn't receive anything at all.
Well, Black and Davis was not a case of the equitable concept of fraud. It was ordinary common law fraud. It's just that it didn't satisfy different requirements. But my question was whether the concept of equitable fraud has been applied to a case where there is no fiduciary relationship or something akin to that. You've given the example of the Mann case, which I'm not familiar with, so maybe we'll need to look at that.
That is a claim of deceit.
Right, so that's not an answer either.
No, it's right. I have no authority that I've unearthed in which the court has ordered compound interest in such a circumstance. One of the points which we'll see when we look
well, that's very fair, but the question was slightly wider than that, not just compound interest, but where equity has said this is what we regard as fraud in equity, even though it's not a fiduciary relationship claim case or something akin to a fiduciary relationship.
The Janssen case that I took you to before was where there was an unconscionable bargain that wasn't a fiduciary duty case, but it was described as a species of fraud.
Yes. Well, that was really where fraud was presumed rather than proved. That's the way it was put in the judgment, I think.
There is discussion of the fact that there's different levels of it. There's the discussion of the fact that equity will treat hard unconscionable bargains as fraud, that it could also sometimes presume fraud, whereas the common law will always require proof of fraud, which is a second level down, in my sense, a slightly different point as to what is fraud.
Thank you.
Now, it's appropriate then to look at the nature of the claim that's before your lords, my lords and my lady at the moment. And I've noted my learned friend says it's not a claim in dishonesty. We say, well, that's not necessarily, that's not the right test, and in any event, certainly arguable. And we say it is a claim that's based upon conduct that transgresses ordinary standards of honest behaviour. There may need to be an appraisal of the specific conduct in question in relation to that, which we say is best done at trial. The judge summarised the nature of the claim in paragraphs 3 to 5 of his judgment as a follow-on damages claim based upon the decision of the Commission from 2010, which, as he said, has established that defendants unlawfully entered into agreements and or concerted practices in respect of the LCD panels in the period October 2001 to February 2006, and this was an infringement of, amongst others, Article 101. Perhaps just to show you the text of that, we can find that in Authorities Bundle 3. It's in the Britned case, it's at tab 23, page 964. My learned friend and my attempts to keep Authorities Bundle as slim as possible, perhaps unhappily took out the actual relevant statute or provision. You'll see it in the footnote here, page 964. The following shall be prohibited as incompatible with the internal market. All agreements between undertakings, decisions by associations of undertakings, concerted practices which may affect trade between member states which have as their object or effect the prevention, restriction or distortion of competition within the internal market. Now, the decision of the Commission is in the supplementary bundle. Tab 1. I'd like to show you 5 or 6 paragraphs from it. Page 19, at recital 71, there's a description of the infringement in question involved interaction between the major Korean suppliers, Samsung and LPL. LPL were the defendants here, and their Taiwanese counterparts. Paragraph 72, anti-competitive practices, including price fixing in the form of agreements on future prices, price ranges and minimum prices, pricing and commercial matters for specific accounts, on future production planning and future capacity utilisation, exchange of information on pricing, and other commercial aspects, including sales volumes or capacity plans. And you'll see the last sentence, application of these practices took place at a worldwide and at EEA level, directly or indirectly, and was not restricted to specific geographic areas or shipment destinations. And at recital 98, which is page 23, in light of the above, the objective of the anti-competitive arrangements was to increase and maintain prices of the LCT panels for IT and TV applications. Then it's described how it took place at 2 levels, by directly agreeing and entering into price fixing, and yet indirectly by adopting a common understanding of the future strategy on the parameters which determine prices. It's noted there were regular monthly checking of the price, production volume, and so on. And then we can go forward to recital 302, page 80. Anti-competitive object of the parties is also confirmed, page 302, paragraph 302, page 80. The anti-competitive object of the parties is also confirmed by the fact that they took deliberate action to conceal their meetings and to avoid detection of their arrangements. They considered important from the beginning to implement security measures to avoid consequences of the antitrust law violation and made efforts to avoid being in possession of anti-competitive documents. Later on in this paragraph, confidentiality was maintained within the participating companies as well. And 2 further paragraphs. Paragraph 373, at page 94. Given the secrecy with which the cartel arrangements were carried out, it is not possible to declare with absolute certainty the infringement has ceased. It's therefore necessary for the Commission to require the undertakings to which this decision is addressed to bring the infringement to an end, if not already done so. And finally, recital 433. Page 107. Under the heading negligence. It's about 5 lines down, 6 perhaps. The Commission considers that the parties could not have had a reasonable doubt about the fact that they were participating in a worldwide price-fixing cartel and that their behaviour went against antitrust rules. And then 2 lines down, 2 sentences down. The Commission also considers that the infringement was committed intentionally, and as it appears from the facts described in section 4, the parties took precautions to conceal their arrangements and to avoid their detection. Cartel arrangements thereby permeated a significant part of the industry, were conceived, directed and encouraged at the highest levels in each undertaking concerned, and operated entirely to the benefit of the participating producers, to the detriment of their customers and ultimately the general public. Consequently, no mitigating circumstance can be retained on the ground of negligent or unintentional infringement. Companies concerned knew they were breaking competition rules and took steps to conceal that behaviour. Now, we say that could come, or does come, within what equity would regard as fraud. Equity was a court of conscience. This is unconscionable behaviour of a serious degree. My learned friend cites two authorities which he says answers that submission. So we need to look at those. Norris and Government of the United States of America is the first one. And it is in Authorities Bundle 2, tab 18. In our case, the judge of first instance expressed the view, paragraph 28, that he was doubtful that the authority for the case is authority for the broad proposition for which it was cited by my learned friend. He was entirely right about that. Now, this was a decision of the House of Lords. It was an extradition case, and if we turn to paragraph 6, page 706. The gentleman in question, Mr. Norris, in resisting extradition, contends that participation in a cartel in the absence of aggravating conduct was not at the material time, which is 1989 to 2000, a criminal offence at common law or under the statute law of this country. Accordingly, it is submitted the conduct of which is accused in the United States would not at the time have been criminally punishable here, with the result the requirement of the Extradition Act is not satisfied. So the question there was an entirely separate one. The question is whether or not what Mr. Norris was accused of having done between 1989 and 2000 was a criminal offence under English law at the time. And the House of Lords found that it wasn't, and the absent aggravating factors, and that's paragraph 62 of the judgment when that was said. That's page 723. And it said there, the committee considers that mere price fixing, that is the making and implementation of a price fixing agreement without aggravating features, was not at any time relevant to count 1, a criminal offence. And so therefore his appeal must be allowed and the order for extradition must be quashed. So the issue in that case wasn't the issue in this case by any stretch of the imagination. And my learned friend relies in particular upon paragraph 17, which is at page 709. Where there's a summary of a number of authorities that have been referenced, that a common law recognised that an agreement in restraint of trade might be unreasonable in the public interest, and in such cases the agreement would be held to be void and unenforceable, but unless there were aggravating features such as fraud, misrepresentation, violence, intimidation, inducement of a breach of a contract, they were not actionable or indictable, and so on. Now, that, in my submission, doesn't answer the question as to whether or not equity would have regarded this as fraud. And importantly, if we go to paragraph 24, page 713, it's noted that in the past 60 years, the law relating to price fixing has been radically, if somewhat gradually, changed through the medium of legislation. And then there's a detailed description of the evolution of the statutory provisions and regime in relation to competition. And at paragraph 32, page 714, reference is made to the fact that the UK became subject to what are now Articles 81 EC and 82 EC of the EC Treaty. The practical effect in summary terms of those provisions was to create a new tort of breach of statutory duty in respect of cartel agreements which affected inter-community trade. They also exposed the parties to such agreements to civil penalties at the hands of the Commission, subject to review by the ECJ. However, they did not give rise to any criminal liability. Now, I don't propose to go any further into this, save to make the point that risk repeating myself, this isn't authority on the question of the equitable jurisdiction to grant compound interest. And what has happened, of course, is
But there's nothing about whether equity would regard these actions as fraud. That's the higher level point.
Yes.
It's certainly nothing to do with interest, but it's
yes,
it's the equitable scope of the equitable concept of fraud. It's not touched on here.
it's even further removed. My lady's right. And if one were to be considering that, it would be relevant to consider the overall circumstances as to how the world, shall we say, now looks at anti-competitive practices and price fixing in particular. Public policy isn't an immutable concept that doesn't evolve. And it might be that something that equity on Monday regarded as not being a problem, but it might have regarded as a problem on Tuesday if there had been changes in the social fabric or whatever the thing might be. The question is whether it's unconscionable, ultimately. That's the touchstone of my submission. Now,
Well, you can get compound interest if the judge, in the light of contemporary standards of behaviour, thinks the defendant's conduct is unconscionable.
no, the point I was making was slightly narrower than that, my lord, which is...
Hope so.
Sorry?
I said I hope so.
And it's very much the point I made right near the outset. The fact that the question is whether it comes within the principles.
Yeah.
And if the ultimate principle is unconscionability, and I appreciate it, it's not as, I won't put it as low as that, but equity regarded hard bargains as unconscionable, hard bargains as being fraud. That expression was even used in certain circumstances, as we saw, to describe breaches of fiduciary duty. Entering into a practice where the object of which is to distort the market and cause harm to the general public, my submission is something, particularly today, that equity would regard with quite some disgust. Now, my submission, it comes within the equitable jurisdiction. I need to now show you with the other authority my learned friend referred to, which is the Gold Shield case. I should note, of course, before I do, in Norris there was also the reference to aggravating factors. Aggravating factors, as we'll see from Gold Shield, can involve the sorts of things that have happened here. We've got deliberate concealment of the wrongdoing and knowing participation. Now, the Gold Shield group case is at the next tab, tab 19. Again, in my submission, this case says nothing about equity's meaning of fraud and says nothing about the jurisdiction to award compound interest. This was effectively a pleading issue. The defendant companies were indicted for conspiracy to defraud. And you can see it in paragraph 3 of the judgment, page 740. That it said, that it's explained that the companies were concerned in the manufacture and sale of drugs, and mainly generic drugs, and the case being made against them is that in their respective capacities, defendants dishonestly fixed and maintained the price of drugs. And the issue is identified in paragraph 2, quite pithily. The issue in the appeal before the House is whether a prosecution will lie against the appellants for conspiracy to defraud the Secretary of State for Health and others by fixing and maintaining the price if the steps taken in pursuance of the alleged conspiracy were dishonest and deceptive. I'll ask you to note those words. If the steps taken in pursuance of the alleged conspiracy were dishonest and deceptive. Because if we now turn to the meaning of the offence, which is at paragraph 11, page 743. Reference to decision of Lord Justice Moses as to the meaning of conspiracy to defraud. And it's sufficient to refer to the definition formulated by Lord Goff in the YU Sang and the Crown, that the conspirators have dishonestly agreed to bring about a state of affairs which they realise will or may deceive the victim into so acting or failing to act that he will suffer economic loss or his economic interest will be put at risk. I underline the word agreed because the point in this case, as I'll show you, is there was no allegation that they had that the various defendants had agreed to anything. It was simply said they did price fixing. And the point was that fell short of meeting the ingredients for the indictable offence.
So it wasn't a conspiracy.
It says, this is in the next sentence, it hardly needs to be said that while the subsequent actions of conspirators may be cogent evidence of the content of the agreement, the actus reus is the original reaching of the agreement. And the focus of the court trying a conspiracy case has to be on the content of the agreement and the contemplation of the parties when it was made. That's because they have to have dishonestly agreed to bring about a statement of affairs. And paragraph 12, there's a reference to what had been set out in various summaries of the case. But the second sentence, the contrary submission advanced by counsel for the appellants, so that's the defendants, is that price-fixing agreements which he described as cartel behaviour are not in themselves criminal, even if made secretly and with an element of deception, which may be widely regarded as dishonest. Conspiracy to defraud would require proof of agreement to make false or misleading statements or other actively fraudulent behaviour. And having looked at that, if we now go back to what the indictment actually said, so paragraph 7, page 741, the indictment on which it is proposed to try the appellants is in general terms. The particulars are that the appellants, in certain dates, conspired together with others to defraud by dishonestly fixing and maintaining the price, manipulating spied medicine and so on. It wasn't said that they entered into an agreement to do such things. So the allegation was that they did something and that somehow met the requirements for the indictment. And that was held not to be correct, and that's, in my submission, what's ultimately to be found in paragraph 18 of the judgment. It said the voluminous material in the prosecution case statement contains within it quite sufficient notice of aggravating elements, consisting of allegations of lies and positive deception. The appellants could not possibly maintain they were left without notice of the acts of this nature on which the prosecution could rely in putting forward a case of conspiracy to defraud on the basis of agreement to commit such acts. The difficulty is that although they could very well charge them with that, they have not done so as the indictment stands. If necessary, the particulars should make clear to the defence the case which it must meet. And then the last sentence on that paragraph, for that reason we must regard the indictment as effective as it stands. So my submission, this case again, clearly not authority for the proposition for which it is cited. Now,
It looks to me as if it may be saying that although price fixing is dishonest, for conspiracy you've still got to prove a conspiracy.
yes. You've still got to allege the relevant requirements of the conspiracy, which is the agreement to do the price fixing and so on. And what that carries within it is, of course, that the conspiracy to price fix would be dishonest. Now, so that puts those authorities to one side. That's what my learned friend relies upon in saying why we're wrong on ground 1. I ought to mention then, take you to Westwitcher itself, because Westwitcher is the perhaps the only case where there's been one of the only cases when there's been an attempt to discuss what Lord Brandon had intended in La President. West Deutsche, as I'm sure the court is aware, the underlying claim was for recovery of monies paid by a bank in pursuance of an ineffective contract. And the question was whether the bank was entitled to compound interest on the sums they recovered. So it wasn't a fraud limb case, nor was it a fiduciary limb case. Ultimately, the reason I say ultimately is because and the House of Lords was split 3-2 on the decision. But what they all agreed was that is to overturn the decision of Sinclair and Braun. That was the decision that had been relied on below, to say when there's a void contract, the recipient of the money is held on a resulting trust, giving rise to the engagement of the equitable jurisdiction on the fiduciary. And as we'll see, the House of Lords' appeal took an unexpected turn because their lordships invited submissions on whether Sinclair and Braun was correctly decided it wasn't correctly decided, overruled it. Now, Lords Goff and Lord Wolfe nonetheless were of the view that it was appropriate to consider whether equity's jurisdiction could still be engaged. Lords Brown, Wilkinson, Slynn and Lloyd did not agree. Two principal reasons for all of them. One was that the argument had not been fully argued. Lord Lloyd said the point was of general importance but was scarcely argued. And the second reason was they felt it would be, as it was common ground, that to award compound interest exercising the equitable jurisdiction in this circumstance, which was a non-fraud claim, non-fiduciary duty claim, would be breaking new ground, introducing new categories. They held it, or felt it would be usurping the function of Parliament to expand it in those circumstances. Now, just thinking about those two reasons, first, that it hadn't been fully argued, wouldn't be a reason for saying that therefore it's not possible to run the argument. You see what I mean?
I think it was a case, wasn't it, where the local authorities basically said, you spent enough on legal fees on this case, you're on your own.
Yes, they said, looking at, it's in the report, I think Council says something like, looking at the time, we want to focus on the other point, and we don't want to incur the cost of another day. So we're happy for you to make a decision on what you've heard or read. And so you need to be careful about treating it as being a full and complete determination of what equity's jurisdiction is. And as we'll see, questions were even left open by Lord Brown Wilkinson. Similarly, the view that they would be expanding the categories to break new ground doesn't, in my submission, apply to our issue before court today, which is whether or not we're within an existing category. Noting the time, I'm not going to... Lord Goff felt that equity should come to the aid here because justice demands it. But I'm not going to... But he didn't discuss the fraud limb, so I'm just going to leave it at that and go on to Lord Brown Wilkinson's judgment, which is... Authorities Bundle 1, Tab 10. Page 259. In paragraph D. Just ask you to note that Lord Brown Wilkinson, when he discusses the equitable jurisdiction, says, in the absence of fraud, courts of equity have never awarded compound interest except against a trustee or other person owing fiduciary duties who is accountable for profits made from his position. And then he says, equity awarded simple interest at the time when the courts of law had no right under common law or statute to award an interest. The award of compound interest was restricted to cases where the award was in lieu of an account of profits improperly made by the trustee. So what he's discussing there is he's taken fraud out of the equation and then is discussing the approach of equity to fiduciary and trustee claims. As we'll later see, there was an attempt, an optimistic one, in Black and Davies by the claimants to argue by using the words "in the absence of fraud," Lord Brown Wilkinson should be taken to have said, whenever there's fraud, you can have compound interest, even if it hasn't been obtained and retained. Which is clearly not the right interpretation when one sees, because over the page, Lord Brown Wilkinson discusses and effectively agrees with what's in La Pintada, which was where Lord Brandon had said the Chancery courts, again differing from the common law courts, had regularly awarded simple interest and ancillary relief in respect of equitable remedies. Chancery courts had further regularly awarded interest, including not only simple interest, but also compound interest when they thought that justice so demanded. Just pausing there, it's the words "justice so demanded" which were part of what was fixed upon by Lord Goff in this case, to say, well, this is why it really should be available here. That is to say, in case where money had been obtained and retained by fraud, or where it had been withheld or misapplied by the trustees. And then,
I think it's fair to say that even Lord Goff didn't treat those terms without any limitation. He was very much confined to restitutionary claims in equity.
Yes. The point, and I'm not seeking to say that in West Deutsche the court actually decided the point that we're arguing here. What I'm just looking to illustrate is that, particularly in the case of, here we have Lord Brown Wilkinson, he doesn't discuss the fraud limit, other than say, to take it out of his discussion, might put it that way. And he does it again in the very next paragraph at D on page 260. These authorities establish that in the absence of fraud, equity only awards compound as opposed to simple interest against defendant who is a trustee or otherwise in a fiduciary position by recouping from such defendant an improper profit made by him. Now, Lord Wolfe was in the minority. The reason I wish to show you his decision is because he seeks to trace where Lord Brandon might have sourced the expression that he used when he's talked about money obtained and retained by fraud. That's at page 279D. Said, describing the situation before the court there, the situation is one in which compound interest would be awarded because it would be unconscionable to allow the local authority to make a profit out of a contract which was void because it had exceeded its own powers. It's very much an analogous situation to those where equity has traditionally provided remedies. Perhaps the best example is provided by specific performance. Page 282, at the top is a heading, "No distinction in principle between simple and compound interest." The case is one where there is jurisdiction toward equitable interest, and whether compound or simple interest is recoverable depends on the facts of the particular case. If it is not a situation where the defendant would have earned compound interest, then as in Burdick and Garrick, there'd be no profit of compound interest, so it would not be awarded, simple interest would be awarded instead. He then refers to the Law Commission's approach and a report of the Law Commission which discussed the equitable jurisdiction. And you'll see at the bottom of this page, he doesn't fully agree with what is said there, but you see at the bottom of the page, he says, "It is true, in the first of only the two cases referred to by the Law Commission, the Privy Council appeared to," and that's Johnson and the King, "the Privy Council appeared to think that interest was not payable in the case of an overpayment by mistake." And then he says, "It is a case to which I'll refer later, but it was not concerned with the equitable jurisdiction to grant interest, only the common law jurisdiction. What is of interest is what Lord Norton said as to the power to award interest." And then he reads out the words I'll ask you to read that paragraph that's indented here. This is and we'll look at that case, but just asking you to note that the formulation in Crown and Johnson is there is no doubt whatever that money obtained by fraud and retained by fraud, not obtained and retained by fraud, can be recovered with interest, whether the proceedings be taken in a court of equity or in a court of law. And over the page at F is where Lord Wolfe said, in relation to President of India and La Pintada, the House had been referred in the course of argument to the Report of Law Commission, and I suspect that Lord Brandon restricted the jurisdiction of the courts toward interest to equitable remedies following what was stated in that report. Likewise, as to the distinction which he drew between the jurisdictions towards simple and compound interest. According to the report of argument, counsel did not address the House on the limits of the equitable jurisdiction. Therefore, although any statement of Lord Brandon is entitled to the greatest respect, I do not regard these two dicta as indicating that Lord Brandon held a considered opinion inconsistent with my views, which I've set out above. It may well be that he was doing no more than describing the situations where in the past the equitable jurisdiction had been exercised. The point here is that it suggested that the source of the formulation used by Lord Brandon might have been the Law Commission report, which itself relied upon effectively two authorities on this, Wallersteiner and Moyer, which was a fiduciary case. It was about a director in breach of fiduciary duty, so it doesn't take things further, or Crown and Johnson. Now, the upshot in my submission is that these authorities don't stand in the way of our submission, because they don't discuss and define the ambit and the principles underlying the fraud limb, so as to say that it means something extremely narrow. In my submission, equity jurisdiction should apply here. And the focus then, in my submission, not so much on the nature of the cause of action, but on the claim. So to explain that, a claim in deceit is a claim in tort. That doesn't mean that every claim in tort engages equity's jurisdiction. It is the nature of the claim that's brought in tort. And we say that the claim that's here being brought is a claim which has features which are of the sort that equity would regard as fraud. So we say that the judge was wrong in his conclusion that Lord Brandon's limb wouldn't apply to this sort of claim. That's ground one.
Yes.
Move to ground two, if I may.
Ground two. Yes.
Thank you. And we say that the judge erred in law in concluding that to engage the jurisdiction toward compound interest, it is necessary that cause of action is one in fraud or of which fraud is an ingredient. Lord Brandon's formulation, as we've seen, was where money had been obtained and retained by fraud, which was a dictum in a case where it was not necessary for Lord Brandon to discuss precisely what that meant, nor did he do so. The expression was not where money is claimed in reliance upon a cause of action. And the source of Lord Brandon's dictum is not identified in the judgment, but as we've seen from Lord Wolfe's speech in Westwichere, might have been ultimately derived from the case of Crown and Johnson. And I'll ask you to look at that. It won't take very long at all. It's in Authorities Bundle 1, tab 6. Summarising both of our skeletons, so the facts will be familiar, I suspect. The Army contracted with Mr. Johnson to provide some services. He was a government contractor. He put in a bill. He received, it was an inflated bill. He received a sum in excess of what it was due. He retained it. He was prosecuted and convicted of fraud, a criminal prosecution. admission, there was also then a civil claim that was brought to recover the monies, and in that, a claim was made for interest. But the claim in his statement of defence, and this is at page 109, Johnson admitted overpayment and tendered repayment. The claim was brought in mistake and fraud in the alternative. He denied fraud, accepted the overpayments were due to mistake. The case went to trial, and the Crown didn't try and prove or pursue the alternative claim in fraud. They effectively just relied upon the admission of mistake in order to obtain judgment for the sums. And in this case, as you therefore see at page 111, 5 lines down, the difficulty is that the Crown seems intentionally and deliberately to have put aside all questions of fraud. In the reply on behalf of the Crown, the money paid in court was accepted in terms as money paid by mistake. No attempt was made to give any evidence of fraudulent pretences which had been proved to the satisfaction of the criminal court. And at the end of this paragraph, if the Crown intended to rely on fraud as giving the right to interest, the case ought to have been stated plainly and proved clearly. And it's then when the court went on to say, in order to guard against any possible misapprehension of their Lordship's views, they desire to say that, in their opinion, there is no doubt whatever that money obtained by fraud and retained by fraud can be recovered with interest, whether proceedings be taken in a court of equity or in a court of law, and so on. So that, again, the authority that they were relying upon, or practices aren't discernible from the report.
That seems to say that you could get compound interest at common law. What would be the basis for that?
In fact, actually, they don't identify between compound and simple interest in that case, which is another part of the complexity. They just say interest.
Interest, yes, you're right.
And that appears to be, nonetheless, become part of the source of what became. So the archaeology, as I said, my lords, and my lady, is not simple, but we say it does support our case. So just pausing for a moment, the formulation in Johnson was obtained by fraud and retained by fraud, not obtained and retained by fraud. And in my submission, that suggests alternatives. Either the money has been obtained by fraud, or the money has been retained by fraud. In my submission, it would be surprising if the requirement was that the money has been obtained by fraud and then there's been a further fraud leading to the withholding of the money. And if the intention was to say it just needs to have been obtained by fraud, then it doesn't, in my submission, make much sense to have said obtained by fraud and retained by fraud.
Isn't the theory that underpins this the idea that somebody has got hold of some money by fraud and they're sitting on it? It's the pot of money idea, isn't it? That they've got a pot of money that they've obtained and they are retaining as a result of their fraud, one or two of their frauds.
That leads to a question of what is the underlying rationale for the award of compound interest here. Is it only to strip the defendant of profit, or is it also compensatory in the sense of compensating the claimant for the claimant's loss? Now, as I'll seek to show you, noting the time, there's authority to say it's actually compensatory. And I'm going to, before I do that, just take you to Kuwait Oil Tanker and Al Baida, which is in Authorities Bundle 1, tab 12.
I just see before you do that in the report of the argument at page 819 of the report, there is reference to two cases, Fruling and Schroeder and Sutton and South Eastern Railway, which seem to be to do with when you can get interest for fraud.
You might think that, and I've read them, and that's why I said in my skeleton that they don't appear to support it. I don't think my learned friend demurs from that.
So we're not going to be helped by looking at that.
We're not helped at all. And in fact, if we're going to just stay on that point,
Don't go to them if you don't want to.
I'm not going to go into them, but you'll also see in the report there's a reference to, in the argument at page 108, it was argued the money was fraudulently obtained and improperly detained, and then there's a reference to a statute. And I've cited that in my skeleton argument. It's a statute relating to, I've forgotten the precise formulation of it, sorry, one moment.
Well, it's in your skeleton.
It is. It is. Yes, it's the Exchequer and Audit Departments Act of 1866, and it talks about accountants of the Crown, and in all cases in which it shall appear to the Comptroller and Auditor General that the balances of public money have been improperly and unnecessarily retained by an accountant, then he's liable with interest. So it doesn't, again, help us. Which is the world in which we're operating in seeking to decide this issue. Kuwait oil tanker. I only want to show one point. I only take 1 point from this, is that Bundle 1, Authorities Bundle 1, tab 12, decision of the Court of Appeal. This was a claim based upon the tort of unlawful means conspiracy and also on the basis of breach of fiduciary duty. The claim was made out, compound interest was awarded on the basis that fiduciary duties had been breached. Lord Justice North gave the judgment of the court. There was a question of interest. It was effectively a double actionability question. It was whether or not an award of interest was precluded by the double actionability rule as being contrary to the law of Kuwait. And you can see this at paragraph 196 at page 382. Three questions that were considered in the appeal. Was an award of interest precluded by the double actionability rule? If not, was it a case in which it would be appropriate as a matter of discretion? Award interest at all? If so, should it be awarded on a simple or compound basis? There doesn't appear to have been any challenge to the fact that under English law, compound interest was available. It was a fiduciary duty case. Paragraph 210 Lord Justice North says this, page 386, having referred to the Lord Brandon in President of India. In such a case, the award of compound interest is made on the basis that a trustee misapplying money for his own benefit and a person obtaining or retaining money by fraud, who is to be similarly treated, should be obliged either to account in full for the benefit he has unjustly derived or, in lieu of such account, to pay compound interest when the circumstances justify an award on that basis. I learned from him relies heavily on the next words. The rationale was historically and essentially that of restitution, i.e. that a fiduciary should not be permitted to make a profit from his trust. But as explained by Lord Denning in Wallensteiner and Moyer, it is also a means of ensuring full compensation when the wrongdoer deprives a person or company of monies employed in trading operations. There's further authority on this point and nature of it. But whilst again there was no need for any laser beam focus on the issue of equities jurisdiction in the context of fraud, it is noted, it might wish to be noted, that Lord Justice North used the expression obtained or retained by fraud. And that goes back to the example I gave at the outset. If you obtain money by a non-fraudulent, if you have a non-fraudulent cause of action to recover money, but if the defendant has managed to keep hold of your money because they have subsequently practiced a fraud upon you, should that not be a position when compound interest would be obtainable? And if so, that suggests that the fraud doesn't have to be inherent in the cause of action itself, which is our ground two.
Having just said that in Westdeutsche the majority declined to expand on what Lord Brandon said, isn't it more likely that the word "or" was simply a slip?
Possibly, Manuel. But what's consistent, what I take more from it is firstly, if you look at Crown and Johnson, it used a different formulation, which in my submission is closer to or when one thinks about it syntactically. But secondly, the description of the rationale here is consistent in my submission with or, having that example that I just gave the court.
This is a terribly elementary point I'm making. Forgive me for putting it this way. But if the correct formulation were obtaining or retaining, you could simply cross out the words or retaining. Obtaining by fraud would be enough.
If in that circumstance, though, you wouldn't be able to claim compound interest if it was obtained without fraud, but it has been retained by fraud.
Obtained by fraud.
Yes.
But that's enough.
That would mean that you have to show that would be the judge's view, which is that, in our case, that the fraud must be in the cause of action itself. You would have to have said obtained by fraud. You would no reason to say or obtained or and retained by fraud.
Okay, right. Anything else from the Kuwait case?
No, nothing from that case, and I wish to take you then to the last authority and last point on ground 2, to the Court of Appeal decision in Took and Hood, which is at Authorities Bundle 3, tab 27. This was a very optimistic argument where a defendant fraudster who was liable for damages, having misled the claimant to sell some classic cars at an undervalue, said that the damages that the fraudster was liable to pay to the claimant should be reduced to take account of the fact that the claimant had sold these goods at an undervalue and received some money, and so it had the time value of that money before the claim got to trial. And so compound interest, so there should be some reduction in the fraudster's liability to take account of the fact that the claimant had the benefit of the money. That was rejected in strident terms by the Court of Appeal. But one of the points that was made by Lady Justice Andrews at page 1224, 1224, at A, where it was said the analogy with compound interest is even more difficult to maintain, given that compound interest is an award in equity and an adjunct to dishonest behaviour designed as a means of discouragement of such behaviour. And actually linked to that, if I could ask you to turn back to paragraph 30 at page 1217, there's a discussion of the fact that when assessing damages for deceit,
Sorry, which page? I've lost
page
it.
1217, my lady. Paragraph 30 is a reference to the Smith New Court case. And the point was made that in that case, Lord Steen explored the policy justification for differentiating between the extent of liability for civil wrongs in general and those involving intentional dishonesty. And then the policy that was spelt out is that there could be no doubt that you would say that everything would be taken into view that would go most against the will of the wrongdoer. Now, my submission, that policy rationale, which you can see is Lady Justice Andrews later in her judgment saw was also affecting the basis for compound interest has now jumped to dishonest behaviour. My submission supports our argument on ground 2. So,
Given the emphatic nature of this judgment, it's hard to think why permission to appeal was ever given.
I have just noticed the identity of the judge who gave permission to appeal.
it escaped my notice. The respondent's notice. My learned friend says it's a requirement of the fraud limb that a defendant obtained and or retained money belonging to the claimants. That wasn't advanced below. It involves a gloss on words that aren't to be found in Crown and Johnson, aren't to be found in Lord Brandon's explanation. As I said, Lord Brandon didn't say that the defendant has obtained the claimant's money. It's said to be based on the Court of Appeal decision in Black and Davies, which is in tab 15 of the authorities bundle. I think it's authorities bundle 2.
Yes.
I'll summarise the facts and my learned friend no doubt say if I get them wrong. Mr. Black, the claimant, was a trader in copper futures on a massive scale. He used a brokerage firm called Brandeis Brokers, and Mr. Davies, the defendant, was the managing director of Brandeis. Brandeis pursued an arbitration against Mr. Black for sums due when positions were closed out, when the market moved against him. Mr. Black counterclaimed alleging 2 things. One, that there'd been dishonest trading by Brandeis, and secondly, that its MD, Mr. Davies, had fraudulently induced Mr. Black to remain short on certain positions. In the arbitration, Mr. Black succeeded on the first point, which was the dishonest trading, but there was no decision reached on the deceit claim. And the fraudulent trading or dishonest trading was that Brandeis engaged in front running, so they used information that they obtained about what Mr. Black was going to do to then trade on their own account. There was then a settlement of the claim as between the claimant and Brandeis. So no ruling on the deceit action. The settlement agreement didn't settle any claim that Mr. Black had against Mr. Davies, who was the managing director of Brandeis. And Mr. Black then brought a claim in deceit against Mr. Davies. He succeeded in that at first instance before Mr. Justice Buckley, and in a separate judgment, Mr. Justice McComb, as he then was, held that there was no jurisdiction toward compound interest in a claim for deceit. And the Court of Appeal reversed the findings that there had been deceit. And so when they came to discuss the compound interest question, it was expressly overturned. And we've got it open, tab 15 at page 444, paragraph 80. It recites the consequence of our disposal of the appeal was the judgment will be set aside, compound interest will be academic. Since it's one of general importance, it's appropriate we should express a view in it. Owing to shortage of time, we were unable to hear oral submissions. The parties were content to rely on their written submissions, which have been supplemented since the date of the hearing. So it's an obiter decision without the benefit of oral argument. Their lordships held, different to the judge at first instance, that there was power to order compound interest in a claim for deceit, but only if the defendant has obtained retained money. And this is paragraph 87. And the lordship said in the penultimate sentence, Mr. Davis's fraudulent misrepresentation did not cause him to obtain and retain money belonging to the black parties. It caused them to lose money by trading in the markets. So he hadn't received anything at all. He made a deception on behalf of his company, and there's no finding that Mr. Davies received anything, or in fact that even that his company received anything. Earlier on in this passage, when referring in this paragraph, when referring to Lord Brandon's limb, you'll see it refers to it, that is to say, a case where money has been obtained and retained by fraud. In other words, where the fraudster has had in hand a fund which he has or is deemed to have made use of for his own benefit. And my learned friend seizes on those later words, though, retain money belonging to the black parties. Now, given that this wasn't a case where Mr. Davies had received anything at all, or made any benefit, as you see, simply the case was put that the claimant had lost money, or the claimant had lost money. There was no need in this obiter judgment without the benefit of full argument for the Court of Appeal to focus specifically on whether or not there needed to be effectively a proprietary link, whether or not the defendant needed to have received the claimant's actual money. So my submission, this passage here is not authority for saying, shouldn't be treated as authority for saying, that it is required that the defendant has actually received the claimant's money. That wasn't the expression used in the authorities, and it's obiter, and without the benefit of full argument, on an unnecessary point. And of course, the earlier formulation used is a fund which he has in hand. Now, as I've addressed already, Lord Brown-Wilkinson treated fraud as being apart, or took it as being apart from the fiduciary limb. So when he discussed the rationale for compound interest, he appears to have treated fraud as being potentially a separate category. And Tuke, which we saw, supports the argument that compound interest could be an adjunct to dishonest behaviour. And that's consistent with the approach to fraud claims more generally. And the Mann case, which I think is the last authority I need to take.
Just before we leave Black and Davis, you're right that what's said on the cross appeal is obiter. It's of some significance, isn't it, that a rather formidably composed court, including Sir Martin Norse, whose use of the conjunction "or" you were placing emphasis on earlier, but this court said 3, not 2 of their lordships in Westdeutsche were of the Brandon school, as it were, and that the formulation obtained and retained is used again and again in this paragraph.
Yes, but again in this case, it was not necessary to explore that distinction. So it is right, and we can see it. What we can see is in what appears to have been the origin, Crown and Johnson, obtained by fraud and used by fraud, and the formulation used by Lord Brandon obiter in La Pintada, and then that's used later on. What hasn't been explored is quite what that means. That's what we say. And we say it's consistent with the principles. And the Mann case I wish to take you to, if I may. Thank you. It's bundle 3, authorities bundle 3. Tab 16. No, that's not right.
Yes.
It is. I'm in the wrong. Must be authorities bundle 2 then, perhaps. It is bundle 2. This is Lord Justice Moore-Bick. And at page 545...
Who was counsel in La Pintada?
Yes, and also counsel in this was a certain Geoffrey Voss, QC, who was for the defendant. And you'll see at page 545, there's a heading, interest. It had been held that a claim in deceit had been made out against the defendant. And so the question was whether to order compound interest. And you'll see it was common ground, paragraph 318. The court has power in the exercise of its equitable jurisdiction to award compound interest and damages only in case where money has been obtained and retained by fraud. On the face of it, Western Star did obtain and retain, as a result of fraud, both the purchase price and the value of the intercompany loan. Effectively, what had happened if there'd been a misrepresentation leading to a share sale. But there was, I think, an assignment of rights, which is why you'll see that Mr. Voss submitted a Freightliner, which was the original misrepresentor, I think, did not obtain or keep the proceeds of fraud, and that if it's to be taken as having done so, I should exercise my discretion in a way that would not punish it for something for which it was not truly culpable. I think I've got that the wrong way around. Yes, it was Western Star that made the misrepresentation, and then the money went on. Now, the basis for Mr. Voss's, this is paragraph 320, first submission was that the Freightliner did not in fact obtain the benefit of the payments. That is no answer to the claim, because Freightliner now stands in the shoes of Western Star. And it's, in my view, this is clearly a case in which the person liable for fraud has obtained and retained money as a result of that fraud. I'm satisfied that I have jurisdiction. Now, Mr. Voss's second submission depended on the twin propositions that Western Star did not behave in a disreputable manner, being liable vicariously for the fraud of Mr. Ellis, and that award of compound interest is punitive in nature. I do not think either of these is sustainable. There's discussion then of the vicarious liability, and then it said, in this context, it's important to bear in mind that an award of interest is not made with a view to punishing the wrongdoer. In some cases, it may be intended to ensure that the wrongdoer does not profit from his wrongful act, but more commonly, it is intended to ensure that the injured party is fully compensated for loss. And so on. So, my submission, that supports the point that if it's compensation, necessarily depriving the wrongdoer of profits, and if it's an adjunct to what equity would regard as unconscionable behaviour, then there should be a liability, or at least the jurisdiction should arise, and then the question of whether jurisdiction should be exercised is a matter of discretion. If I might then finally deal with ground 3. The judge, after expressing his conclusions that the claim of compound interest should be struck out because fraud wasn't an element of the cause of action, said that in any event, the deliberate concealment which we relied upon is not alleged to have caused LG to obtain and retain a fund for their own benefit. It's in relation to that therefore my clients made an application to amend their pleading. And the proposed amendment is in the supplementary bundle. Tab 6. Page 168. And it's in blue underlining is the proposed wording. To read, if you remind yourselves of it's page 168. The judge refused permission to amend in an extemporary judgment at the consequentials hearing, which is it in core bundle 10C. Paragraph 8, page 161, single paragraph. Do not accept those
It doesn't say in the amendment what the benefit is, does it? That the defendants retain, just that they obtain benefits.
Yes.
What were they? say that they obtained benefits from the claimants, and you expressly disclaim any requirement or even possibility of proving that any purchase that you made originated with the defendants.
Yes, so if I might deal with it this way. Participants in the cartel are jointly and severally liable for the claimant's losses.
Yes.
We say that compound interest under the fraud limit is essentially compensatory. It's not necessarily applied simply to strip the defendant of profits that it's made or deemed to have made, but also to compensate the claimant for its loss. We say that the losses suffered by the claimant, which are going to be a matter of the trial in 11 weeks or so, will mirror largely the benefit received by those participating in the cartel. All of those participating in the cartel. And we say it's therefore not necessary to identify the precise money received by a particular cartelist, because they're all jointly and severally liable. And we say that one can gain support from that, from the Central Bank of Ecuador and Contrecourt case, where it was held that where a person is liable for dishonest assistance in a breach of fiduciary duty, even though that person isn't a fiduciary and hasn't possibly even received any money at all, that person's liability is coextensive with that of the person in breach of fiduciary duty, and should be held liable to the same extent, including for compound interest. We say that by parity of reasoning here, we don't need to plead specifically money or limit our claim to the money that was specifically received by the defendant.
Well, you may be right about all that, I expect you are, but that means, doesn't it, that it's not a part of your case that these defendants have obtained anything from you.
Well, we do say, as you've seen, that they have obtained benefit from their participation.
They've obtained the benefit of higher prices in the market generally.
Yes, and as I think Mr. Justice Marcus Smith said, in Britain, rational people don't participate in legal cartelist behaviour unless there's some benefit to them. Now, at this stage in the proceedings, we can't identify specifically what it was that the defendant has actually received, but we say that there's a sufficient pleading to justify the compound interest claim going to trial. Compound interest, or interest claims, obviously normally dealt with as a consequential matter.
Well, you say it will come out of trial, but it won't. Look at paragraph 49C of your pleading, where you say it's an impossible task. It can't be done.
Yes, but that goes back to my anterior point about the joint and several liability, is that if we prove losses that we have suffered by reason of the cartel, then we can say that the cartelists are liable for that. We say that that's effectively mirrored largely the benefits or money that they would have received, the cartelists, between them. And we say that therefore they're all jointly and severally liable for that, and so the fact that compound interest could be claimed against one means they can be claimed against all.
The middle step of that argument seems to me a very controversial one. You're saying, in effect, they should have to disgorge all the profit they made. It's a different claim from saying that they had the use of your money.
I don't think I would put it that way, my lord. If they're liable for damages which equate to my client's loss, and if that loss is effectively a measure of the money, shall we say, that's been received by all of those participating in the cartel.
Well, why?
would it be? Well, it may not be, but it might be one way of measuring it. And what this, I should say, what this
Mr.
also...
President, sorry, me next.
Yes, of course, my lord.
You said, and I've got on board, that the better way of looking, I think you'd say, at compound interest is it's compensatory. The post-insolvency period, what's being compensated? Because your clients are out of business, aren't they? They're being wound up.
Yes.
So where's the compensation that's needed? I understand it obviously for the earlier period, but where's the compensatory element? Is it...
So the way in my submission, it's an important point. So in Sempra Metals, if an ordinary Sempra Metal basis, you've got to plead and prove your loss. One thing that in my submission that's clear when you're relying on equities jurisdiction is equity doesn't actually require that you necessarily do that. And even because it doesn't even necessarily require that before you order compound interest, as we saw in fact from the Mann case, that you identify what profit the defendants obtained. It's by reason of the very nature of the jurisdiction, which is partly an adjunct to improper behaviour, unconscionable behaviour. In our case, by reason of the intervention of the insolvency, it is right that unless there is a surplus, incoming creditors' claims don't get interest paid on their incoming claims. And so in that sense, by reason of the intervention of the insolvency, Sempra Metals ceases to be available to us. But the companies are still being kept out of their money, which means that they're not able to make distributions to creditors and so on. And the companies are having to incur the costs that come with an ongoing liquidation, which is the cost of a liquidator, remuneration and expenses. And so there is an ongoing loss to the company in those circumstances, not having the money. And it does, and so therefore it's appropriate to engage the equity jurisdiction. Otherwise there's something of a lacuna here, which is that a cartelist who manages to run a price fixing, participate in a price fixing scheme which destroys the claimant's business and puts the claimant into an insolvency regime, it's better off potentially.
But isn't that really your complaint? Is that it's grossly unfair?
It is grossly.
But I don't know if it said that they put you into insolvency. But let's just say, for the sake of argument, that the line was that by their misdeeds, LG had gone into insolvency, and there's an unfairness, you say, in them being better off because they put you into insolvency than if you'd been able to carry on trading, albeit at a disadvantage. But isn't the question for us whether that unfairness comes within the existing parameters of the law?
Exactly, and that's why, my lady, I haven't put my argument I didn't start by saying there must be a remedy because this is also incredibly unfair. No. I started by looking at what the principles are that equity would engage. And I say, and that it is a reason why in my submission it should be unsurprising that equity should be able to come to aid in these circumstances. So in relation to...
So just
yes.
Building on my lady's question, if you could plead and prove a loss of any kind within the post-insolvency period, then subject only to ordinary principles like remoteness, you would have a perfectly good common law claim under Sempra Metals.
Yes.
So why should equity intervene to give you something where you can't prove you've suffered a loss?
Well, equity is not necessarily they're not necessarily mutually exclusive. If you could, in a claim for tort, one could, in a claim for the tort of deceit, claim one's losses and seek to claim consequential losses on a Sempra Metals basis. Or one could seek compound interest under the court's equitable jurisdiction. One could do that against a fiduciary. So the ability to use one doesn't necessarily rule out the existence or the ability to use the other, and vice versa. My submission.
Okay.
And my lord, my lady, the judge in my submission, in refusing the pleading, in my submission, a large part of his, if not all of his decision, was based upon his understanding of the extent of equity jurisdiction. So in my submission, it's effectively parroted parasitic upon grounds 1 and grounds 2. If you're with me that he was wrong, that actually equity could in principle allow an award of compound interest in these circumstances, my submission that then it should follow that his refusal to allow amendments is also wrong. And certainly his refusal to allow amendments needs to be looked at in light of an understanding of what the proper principles are, which we say is a matter really for the properly done at trial.
I have one other question for
Yes.
you, which is a bit more nuts and boltsy. But it's to pick up my Lord Justice Males's question to you right at the beginning, which is the scope of the trial upcoming in October, which is a damages claim, I think, looking at causation of damage and loss, which would be in the pre-insolvency period. So that's a relatively familiar territory. Are you not opening up a whole new area of evidential inquiry by your amendment by saying that you need to look at what the LG defendants obtained and retained as a consequence of their involvement in the cartel? In other words, you're looking at the other end of the telescope, aren't you? And that is a novel area.
In my submission, that presupposes that it's necessary to identify precisely what they received. So we say that if we're entitled to damages for X, then we're entitled to compound interest in principle on that X, by reason that equities jurisdiction is engaged because of the nature of the claim that's being pursued here. And whether or not there'd be a necessity for a scope of further inquiry, which wasn't, of course, the arguments that were raised before form part of the judge's decision. My submission doesn't then arise on those circumstances, because if we're right that equity can award compound interest on the principal damages claim, then we say that that doesn't require any further inquiry.
Okay, I think that ties in a little bit with your notion that, or your suggestion that there's almost an inference that the court can draw in circumstances like this, that the loss that's been suffered by your clients equates in some way, indirectly, with the sort of profit that has been made by the cartel, that there has to be a link between the two. I think you say that that's really enough for you to get into the catchment of obtained and retained money. You don't need to specify anything beyond that.
Well, we could put it this way. If we're permitted to go forward to trial on this argument, trial judge can decide whether we've proved it, whether we've proved the basis to enable the judge to exercise the jurisdiction, and if so, how to exercise that jurisdiction as a matter of discretion and to what extent. So we say that those are trial issues.
Based on the existing evidential circumference, without raising any fresh evidence, inquiry into what's actually been obtained or actually been retained by the LG defendants.
As things stand, yes. And it may be at the end of the trial that the trial judge, who will no doubt in identifying whether there has been overcharging, will have been looking at what was done or have much greater knowledge of what actually happened and how the cartel and the price fixing was carried out in order to deal with causation and quantum.
So your claim for compound interest is based, is it on the assumption that the case goes to trial, the judge at trial finds in your client's favour, finds what principal sum is due based on facts up to the date of the insolvency, and then you claim compound interest on that sum from that date, is that right? You're not seeking further factual inquiry.
I don't believe so. May I just turn my back for a moment?
Yes.
Yes. one final point,
Yes.
if I may.
Yes.
It's also the case we say that we assume that defendants are liable for damages for a sum which they should have paid earlier. They profited in the sense of not paying it. And that's where interest often comes in. It's keeping us out of the money. And so we say it's compound interest on that. That's what we're seeking. So unless I can assist you further.
Can I just ask a couple of factual things? I see a lot of the defendants' names have been crossed out. Are the LG defendants the only remaining?
Yes, I believe so. Yes, confidential settlement.
Thank you. Trial due to start in October. Do you have a more precise date than that?
23rd of October, I believe.
Thank you. And presumably by now, all the evidence and experts' reports and joint statements and supplementary reports have been served, or is that too optimistic a view?
Sorry, one moment.
Yeah.
Sorry, I should explain, I'm not instructed on the trial, so hence turning around on those points. I'm told that the expert evidence on quantum issues is closed. There is possibly a question about foreign law that's being raised by the other side, possible expert evidence about that. Otherwise, they're gearing up for trial.
What's the time estimate for the trial?
5 weeks, I believe.
And presumably it's gone through the stage of joint memorandum or the rest of it, leaving foreign law aside.
Yes.
Yeah. Okay, that's clear. Thank you very much.
Thank you.
Thank you very much, Mr. Pritchard.
My lords, my lady, this appeal concerns a claim for compound interest. As you've just seen, in respect of a period in which the claimants were not trading, in circumstances where there is no allegation that they suffered any loss of use of money. So in other words, I think it's fair to characterise it as a claim for non-compensatory compound interest. My learned friend just quibbled a little bit on his feet about that characterisation. I'd just like to make clear there is also no allegation in this case that the cartel somehow put the claimants into insolvency, and that wouldn't have been a credible claim to be made. And although he says that simple interest only would be unfair to the claimants, really that seems to be a complaint that it's unfair to the creditors, not to the claimants themselves. That nothing has been said that describes any loss that the claimants suffered from being kept out of their money in the period after they ceased to trade. So that non-compensatory compound interest is being claimed as relief, as you know, in a common law tort, the breach of statutory duty. And it is common ground that in common law, there is no claim for compound interest in the circumstances that I've just described, as in the absence of some loss of use of money. And although there is now extensive legislation that provides particular rules and procedures for claims for breach of these particular statutory provisions, the competition rules, Parliament has not seen fit to provide for anything other than compensation for loss for this type of claim. And so of course, Parliament could have provided provision for compound interest come what may, but that's not something that it's done. Instead, what is being said to you today is that equity should step in and provide that compound interest come what may in circumstances where neither the common law nor Parliament has done so. We say this is an entirely novel claim at the intersection of two crowded fields of case law. One is the law of equity, and the other one is the law applicable to what I might call non-proprietary torts, like a claim for breach of statutory duty of competition rules. And of course, it's right that sometimes a party's lawyers come along and think of a good argument that everyone else who has practiced in the field has missed over the years, and it turns out to be right. And in that case, of course, the argument should succeed. So I'm not trying to say that just because this has never been upheld or even argued before, it is therefore ipso facto wrong. But this is not such a case. The claim, as you know, is now justified on the footing that equity should intervene to assist this common law claim for breach of statutory duty on the basis that my clients obtained and retained money by fraud. And we have two fundamental objections to the claim for compound interest in this case. I just want to distinguish between them. The first objection, this is my respondent's notice point, I only say first in the sense that it's the one that I'm going to address first. Yes. The 2 points are of equal value. The first objection is that there is no allegation in this case that my clients obtained and retained the claimant's money, or indeed any part of the money on which they are claiming interest. So I'm going to call that the claimant's money point. The second objection is that there is no proper allegation, and by proper I mean one that is sound in law and in equity, that my clients obtained and retained money by fraud. So I'm going to call that the by fraud point. And just for structural signposting purposes, the by fraud point itself comes in two parts. Part A, we say that for a claimant to say that money was obtained by fraud for the purposes of Lord Brandon's formulation of the jurisdiction to award compound interest, the fraud must be at least a part of the cause of action being pursued. In other words, if they want to rely on fraud to claim interest, it must be the case that fraud is part of the basis on which they are claiming, or at the very least could be claiming, the principle. The mere existence of equitable fraud in some sense, lurking somewhere in the background of the case or in the causal chain, is not enough. And this was really the objection that was given by the judge in the judgment, and we say that it was correct. The second part of the by fraud point is an answer to my learned friend's first ground of appeal. And we say that a secret price-fixing cartel is not a fraud within the meaning of Lord Brandon's formulation. This is a response, as I said, to my learned friend's new ground of appeal, his first ground, which is a way to get around the judge's requirement that the fraud actually has to be your cause of action, or at least a part of it. So my learned friend now asserts that although the claim is only pleaded in common law for breach of a statute, the cause of action is properly analysed, he says, we must say, a cause of action in equitable fraud, or at least such a cause of action could have been articulated on the same facts that have been pleaded. And we say that when considering both of those points, the claimant's money point and the by fraud point, it's important to recognise that this is an area that has been repeatedly considered by Parliament. And so the highest courts in the land have repeatedly said, and you've already seen this, that it would be wrong to expand the scope of the jurisdiction to award compound interest in equity beyond that which has been recognised by the courts. You saw Lord Brand Wilkinson said in Westdeutsche that any such expansion would be to usurp the role of Parliament. So those are the points that I'm going to be developing in my submissions. But before I want to do that, I just want to show you some of the key features of the claim, and I'm going to take that from the draft re-amended particulars of claim to take the claimant's case as its highest. And I'm doing that because, going back to a point that I think my Lord Justice Mayles made at the start, take their case at its highest, because the point that we are debating here really is a pure point of law. And the only point of fact that I think my learned friend identified as being one that is left hanging over for trial is the question of whether there was any overcharge. But of course, if there wasn't any overcharge, then there's no quantum, and so the question of interest doesn't arise. So the point of law that we're debating is one that only arises if they're right in saying that there was an cartel overcharge, and in those circumstances, all that is left is this point of law. So if we could take the supplemental bundle tab 6, and if we could just take it back to the beginning, the pleadings, which is at page 153. You can see in paragraph 1, starting at the beginning, that this is a claim for damages in respect of loss and damage suffered by the claimants as a result of the cartel, the LCD cartel. That's the way the claim is described. And further, as my learned friend acknowledged over the page, paragraph 3, it's what's called a follow-on claim, which means that for the purposes of establishing the breach of statutory duty, my learned friend said liability. There's a bit more to liability because there are other issues in the case. But in terms of the conduct that is said to have infringed Article 101 of the treaty, my learned friend's clients will be seeking to prove that at trial exclusively by reference to the findings of the European Commission, which we have set out in the decision. So there is no issue of infringement that is left to be resolved at trial. Then paragraph 5, you can see the claimant's business is described. There are 2 points in paragraph 5. One is that the claimants were in the business, it said, of assembling and selling personal computers and notebook computers and TVs. And so that's the business that they're in. The next point is that the claimants ceased to trade before the end of the cartel period. And then I just note that the period of the cartel during which they were trading is defined as the relevant period. And that comes up again when we get to the plea on interest. I think at this point we can skip forward to paragraph 161. So page 161. And paragraph 36. You see there it said that the claim alleges that the infringements and breaches of statutory duty by the defendants caused the claimants to suffer loss arising by purchases that they made. And those purchases were of LCD monitors, firstly, then LCD panels, and that's a very small part of the claim, but it is there, then notebooks, and then televisions. And then at paragraph 37, you can see they define this concept of a participant panel and a participant product. And just to explain what those mean, a participant panel is one that was manufactured by at least one of the cartelists. It's not necessarily us, but by someone. And a participant product is a monitor or a notebook that contains a panel where the panel was manufactured by a cartelist. So a product that's been manufactured by a stranger can be a participant product, so long as the stranger, somewhere up the chain, got the panel from one of the cartelists. And we'll see how that comes through in the claim over the page.
Well, it's also relevant to note, isn't it, that there are non-participants.
Oh yes, quite so.
So if, for example, somebody who is not a member of the cartel,
that's right,
perfectly innocently,
yes,
sees that prices are going up in the market and takes advantage of that to increase their own prices,
my lord, yes,
then the claimants claim that as part of the overcharge for which you are liable.
That is exactly right, my lord, yes.
And is there any issue about the soundness of that as a principle if they can prove the facts? In other words, that is there any issue about paragraph 32 of the particulars of claim?
My lord, essentially no. So it's very well established at CJU level that you can, in principle, claim for those kinds of losses, subject to...
You've got to prove your loss, of course, but if you can,
That's right. If
then
you can,
it's a sound claim in law.
and subject to remoteness as well. In principle, you can claim for those types of
all
losses.
of that, of course.
And all of this has been dealt with in the expert evidence, the umbrella claims
Yes.
as well. That's what they're called, claims. You'll see that over the page in paragraph 40. Paragraph 40C, you have a claim for umbrella effect purchases, which is where not even the panel was manufactured by, as we've just seen, by one of the cartelists.
So your liability would be exactly the same, even if it were to turn out that all of the products purchased by the claimants originated from people who were not even members of the cartel.
That's true, yes. But the point that I want to make about paragraph 40, the other point that I want to make about paragraph 40 relates to 40A and 40B and the way it's put. Because you can see that originally, if you just read the strike through, it was pleaded that the claimants made... sorry, that the cartel had the following effects. It inflated the prices at which the participant undertakings, in other words, the cartelists, sold the panels. It's now being put in the passive voice instead. The allegation is just that it inflated the prices at which participant panels were sold in the EEA market, irrespective of who was selling them. Because, of course, there can be multiple steps in the causal chain, in the supply chain, before we get there. So that's what a participant panel purchase is, and participant product purchase is defined in the same way. So if, for example, the claimants purchased a monitor from some third party in Taiwan, some complete stranger to the cartel, and that third party built the monitor using a panel that was originally manufactured by Samsung, another one of the cartelists, then that would be a participant product purchase, even though the product wasn't even manufactured by a cartelist. That's the way this has been defined. Then there's paragraph 47, and this is where we have the plea of loss. And so you can see that they say that they made purchases constituting participant panel purchases and participant product purchases. And they also, you can see at C, made purchases constituting umbrella effect purchases. So both of those form part of their case. But there's no allegation here that they purchased anything directly from us, and nor is there any allegation, actually, that they purchased anything directly from any of the cartelists. That's just not part of their case. If we go on to paragraph 49C over the page, this is just the point that Lord Justice Mayles made. They say that it's not possible to trace through the precise supply chains, and they don't intend to do so. And I want to emphasize that for these purposes anyway, that's not a criticism that I'm making of their case. There isn't a requirement in a cartel damages claim that the purchases be made from a defendant. This is the point we've already discussed. So it's orthodox to plead it in that way, without reference to whether the purchases were made from the defendants themselves. But it gives rise to problems for the claim for compound interest that they're now pursuing. If we go on to paragraph 168, you can see paragraph 62. There is actually a claim.
This is almost certainly...
Attention, please. Attention, please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers.
Mr. Pitching, I was going to say just finish the point you're on before we
No.
break off, but I think we better break off now.
Indeed.
Assuming there isn't a very long evacuation, shall we resume? At
Attention,
2 o'clock?
please. Attention, please. This is the Incident Control Officer. A fire has been detected in your building.